All rise.
My lady, Lord Mance asked the question whether there were any materials that indicated the approach of the United Kingdom government, and in fact they are set out in the justice intervention.
I have refreshed my memory.
Paragraph 15, my lord, on page 9.
Yes.
Well, we'll look into that tomorrow. Yes.
So coming back to Alan, if we can just turn, this is volume 1, page 967, we can see where the court turns from the question of admissibility, which it equates with the question whether 6.2 is engaged, and comes to consider the question of the merits, which it equates with the question, is there a breach of the presumption of innocence under 6.2? And you can see the parties' submissions starting at paragraph 110, and the complaint being made that the refusal by the High Court and the Court of Appeal was based on reasons which gave rise to doubts about her innocence. And you can see the particular passages that are complained about, which are derived from the passages that Ms. Williams showed to the court before lunch. And then the core submission is made at paragraph 111, and we submit this is very important because when the court comes to make its decision on breach, it's responding to this submission at paragraph 111. The applicant pointed out that the requirement that a person prove her innocence had been found to be a violation of Article 6.2 in a number of cases. She argued that if a state imposed a requirement that innocence be established before compensation was payable, it was inevitable that a finding that compensation was not payable implied that the state was questioning the person's innocence. So that is the complaint. And in my submission, what you will see is that the court doesn't say that submission is wrong. What the court does is to accept the correctness of that submission, but to say, in fact, the reasons in this case don't contain the vice that they are alleged to contain at paragraph 111, because there is no requirement that the person prove their innocence under section 133, and that is not the test that was applied by the national courts in this case. And if you look in particular at this paragraph, you can see there is a footnote 56, where the applicant makes the point that a requirement that a person prove her innocence has been found to be a violation of Article 6.2. And the footnote refers to 3 cases, and they're the 3 cases that I highlighted in the earlier passage before lunch: Capo, Puig Panella, and Tendam and Spain. And I just want to look at those, 2 of those cases. We don't actually have Tendam in the bundle, but we can provide it for tomorrow. But I want to look at 2 of those cases before I continue in Alan. Now, you've already seen Capo, which is in volume 5, tab 50. It's at MS 2082. And if we just go back to it, I just want to go back through that in a little more detail, because we do submit that this case is very important. And the court can see from the headnote that this was not a case of acquittal on the merits. It was a case of a discontinuation of the legal proceedings, followed by a claim for compensation for unwarranted pre-trial detention. And you can see in the headnote that the claim was refused on the grounds that the applicant had not established his innocence by adducing factual evidence or submitting legal argument to that effect, as was required by the relevant domestic case law. And if we go over to 2083, you can see the summary of the court's finding at B, opposite H5. The requirement in domestic law that the applicant must establish his innocence with factual evidence or legal argument cast doubt both on the applicant's innocence and on the decision of the investigating court to discontinue criminal proceedings against the applicant. And then there is a finding of a breach. It's contrary, this is at D, contrary to 6.2, to reverse the burden of proof in compensation proceedings brought following a decision to discontinue criminal proceedings. It was unreasonable and it infringed 6.2 to require a person to establish his or her innocence. And our submission is that in substance, there is no difference between the test in the amended Section 133 and the test which is considered by the European Court of Human Rights in Capo and found to breach 6.2, and then referred to again by the European Court of Human Rights in Allen. And just looking in a little more detail at this case, the key passages, if a court goes to 2087, you can see at the last sentence of paragraph 19, the appeals board have been compelled to find that the applicant had not established his innocence. In doing so, it had identified a state of lingering suspicion, which did not imply any finding of guilt. And then at paragraph 20, we see the submission being made by the applicant as to why this is a breach of 6.2. And then at paragraph 25, the court notes the appeal board's refusal was based solely on the fact that the applicant had not supported his compensation claim by adducing evidence of his innocence. Although that was founded on 28(1)b of the law, which was shown to you by Ms. Williams, which expressly provides that a person against whom proceedings have been discontinued must establish his innocence by adducing factual evidence or submitting legal argument to that effect, such a requirement without qualification or reservation casts doubt on the applicant's innocence and allows doubt to attach itself to the correctness of the decisions by the investigating courts, notwithstanding the observation in the appeal board's decision that the evidence against the applicant at the time he appeared before those courts had been judged insufficient to justify committing him for trial. It's true, the voicing of suspicions regarding an accused's innocence is conceivable, as long as the conclusion of legal proceedings has not resulted in a decision on the merits of the accusation, and that in Belgian law, a discontinuation order does not bar the reopening of a case in the event of new evidence or new developments. However, the burden of proof cannot simply be reversed in compensation proceedings following a final decision to discontinue proceedings. Requiring a person to establish his or her innocence, which suggests the court regards that person as guilty, is unreasonable and discloses an infringement of the presumption of innocence. And we say that reasoning all applies to the test that's now applicable under Section 133. Now, the same approach was applied by the court in the case of Puig Panella, which you have in the same volume, volume 5, at tab 49. Now, unfortunately, this judgment is only available in French. There is a summary of it in English, and I'm going to attempt an embarrassing on-the-hoof translation of the key paragraphs, but I'm not going to read them out in French because I was humiliated by my own child yesterday for my pronunciation. But the summary on the front is significant. You can see it says the applicant to be convicted of theft, illegal
Perhaps
use...
you could give us a page number.
Oh, sorry, beg your pardon. It's 2063.
Thank you.
So this is the English summary of the case. So he was convicted of theft and various other offences. The Constitutional Court allowed an amparo appeal by documents, but by the applicant. It found he'd been convicted solely on the basis of documents obtained at the investigation stage, which had not been produced or submitted for adversarial argument at trial. The conviction was quashed on the ground that it had infringed the principle of presumption of innocence. So as you can see, this is a case of the quashing of a conviction where the appeal court's not finding that the person's innocent, they're finding that there was an irregularity in the evidence that was used to convict him. The applicant sought compensation for the damage caused by the days he had spent in prison. So this is post-conviction detention. His claim was rejected on the ground that the conviction had been set aside for want of evidence and for an infringement of the presumption of innocence principle. It had not positively been established that the applicant had not participated in the offences of which he'd been convicted. Compensation could have been paid if the applicant had been acquitted on the basis of clear evidence that he'd not been involved in the offences. And the finding there is that the refusal to compensate the applicant for the prison sentence he had served before his conviction was quashed had been based on his supposed guilt or lack of total certainty as to his innocence. That reasoning had cast doubt on his innocence, despite the judgment of the Constitutional Court, allowing his appeal and restoring his right to the presumption of innocence. The voicing of suspicions regarding an accused innocence was only conceivable where the conclusion of criminal proceedings did not result in a decision on the merits. The conviction had remained on his criminal record. Now, so again, you can see how very closely the decision in that case mirrors the circumstances of the application of Section 133. The critical paragraphs of the court's judgment start at paragraph 50, page 2076. And can I refer you in particular to paragraphs 54 and 55? And at 54, the court says this: accordingly, the court is called on to examine whether, by the manner in which they act, the reasons for their decisions, or the language used in their reasoning, the Ministry of Justice and the domestic courts have infringed the right to the presumption of innocence conferred on the applicant, whose culpability had previously been annulled by the Constitutional Court. And then at 55, the court says this: the court finds that the refusal of the Minister of Justice was founded solely on the absence of proof of the non-participation of the applicant in the acts of which he had been accused. And then it said, it is clear from the reasoning of the decision of the Ministry of Justice that it was because of the supposed culpability or the absence of total certainty as to the innocence of the applicant, which is the reason why his request was rejected. And then it said, although this was based on Article 294 of the relevant law, which provides that only persons, that the only people who have the right to an indemnity are the persons who have been acquitted or who have been the object of a definitive finding that they didn't participate in the facts of which they were accused. They say that that requirement, without nuance or reservation, in the circumstances of the case, cast doubt on the innocence of the applicant. It's true that the applicant wasn't called to prove his innocence in the body of his request or in the procedure, and they refer there to capo, but they say nevertheless, the decisions of the minister and of the administrative authorities were founded on the fact that the Constitutional Tribunal, in its judgment, had annulled the charges for non-respect of the principle of the presumption of innocence without finding that he had not participated in the acts.
Now, if that's right,
Yes.
and the key is the absence of certainty
Yes.
as to innocence,
Yeah.
why didn't that apply to Allen?
I beg your pardon, my lord?
Why didn't that apply to Allen?
Why didn't that apply to Allen? My lord, the answer we'll see when we come to see the reasoning of the Grand Chamber in Allen itself.
Yes.
And the answer is that the courts in Allen don't say, one way or the other, whether they find that there is a doubt about the guilt or the innocence of the individual. What they say is, this would have been a matter for the jury. And this is where, your lordship's absolutely right to identify that fine distinctions are being applied. But the fine
So
distinctions...
it's a language point.
It's a language point. And,
Okay.
and Allen is a language case, my lord,
Well,
because the premise of Allen is that the old-style Section 133 cannot be a breach of the Convention because it mirrors the provisions of Article 3 of Protocol 7 of the Convention. And so, therefore, properly construed, Section 133 in its original form cannot be a breach of Article 6.2. And what the court ultimately says, and this is where I'm going to go now, what the court ultimately says in Allen is it's one thing to require somebody to prove they're innocent. That's unacceptable. It's another thing to say that, that if the matter went back to a jury, the matter wouldn't be certain one way or another. Now, you know, I'm not suggesting that that is a particularly wide form of distinction, but there is a distinction there, and the distinction essentially is between the court recognising the proper province of the jury as the finding of fact, and the court or the public authority itself making an assessment of guilt or innocence. And ultimately, my submission is that the vice in the amended section 133 is it requires the Secretary of State himself to form a view about the guilt or innocence of the individual, and to say, this person, on the basis of this newly discovered fact, has not proved beyond reasonable doubt that they are innocent. And that's the vice.
In other words, the Secretary of State in the acceptable section 133 is not posing for herself or himself the question, is this person likely to be guilty? He's merely acknowledging that a jury could
have done. But without saying one way or another what the jury would have done. And the vice is that, as amended, that judgment is now being given to the Secretary of State himself, and that's the place where the court has drawn the line.
So if that very same point had been, a decision had been assigned to a judge in our system...
It would be equally inappropriate, my lord.
If it had been assigned to a judge, then the judge would have been asking himself the question, could I have convicted? And that would have been illegitimate,
yes,
although when it's not assigned to a judge, it's legitimate.
That's right. No, my lord. It's not legitimate if it's assigned to a judge or to the Secretary of State. It's a question that's legitimately assigned to a jury, and once...
Yes, right. What I meant is if it's assigned to the Secretary of State and you have a jury system, then he's not asking himself. He's saying, should this go, or should is this
he can say a jury might have found it.
Yes, well, that's a very odd distinction.
Does it boil down to the difference between, is it an open question and has he proved he was innocent?
Well, look, can I just show you the wording before?
Yes,
let's
just before you leave this one, can we find the domestic test? Is it at 2072? Yes,
my lord, the domestic test is in Authorities Volume 1. It's
you mean the Spanish test?
No, in Puig Panella.
Oh, sorry.
In Puig Panella.
Oh, in Puig Panella, my lord.
Which I think you may find at 2072, but I want to be sure I've got the right page.
Yes, that's it. That is
That's it, is it?
Yes, yes.
And so you are entitled to compensation if you're acquitted
because of the non-existence of the facts that you've been accused of, or because you didn't participate in them.
I think a non-lure probably means a dismissal for some reason other than on the merits, doesn't it? A definitive dismissal.
Yeah.
And
E.g. on the grounds of abuse of process.
And the court's there saying, even though it wasn't explicitly required under 294, in the reasoning, what was said was that it was because he had failed to prove with absolute certainty his innocence. That was the reason why compensation was refused.
So does it follow that if the court had simply said, we're not satisfied that he was acquitted for either of these reasons, that would be all right?
My lord, that might well have been all right, yes, in the sense that that is also a language case. And the distinction with this case is that our case here is that the vice in this case is in the law itself. And that makes this case like Capo.
That I understand.
Because in Capo, the vice is in the law itself, because the law says that you have to produce evidence or legal argument that proves your innocence in order to get compensation. And that's why this is a Capo-style case. Right. So can we now come back to the substance of Allen itself? After that,
also, I wonder if there's also a distinction in that Lord Hughes says in the Spanish case it may be something to do with you're being acquitted for this reason rather than that reason, but in the context of Section 133, we're talking about appeals based on new evidence.
Yes,
and the person has been. The presumption, I think, must be the person was properly convicted before the new evidence was brought forward, because his appeal rights have been exhausted. Either he hasn't appealed, or he's appealed unsuccessfully. And and what you're looking at in the criminal appeal is the impact of the new evidence.
Yes.
And what the Secretary of State is concerned with also is the impact of the new evidence. Whereas the court is asking, does new evidence render the conviction unsafe? The Secretary of State's asking, does the new evidence demonstrate innocence beyond reasonable doubt?
Yes, my lord. And I respectfully adopt that point. And indeed, that is the terminus of my submission. And it's the reason why we say that the distinction that the Court of Appeal sought to draw in this case between general proof of innocence and proof based on a fresh fact is completely empty. Now can I just come back? I'm very conscious of the time. If we just come back to Allen itself, the court's assessment on the merits starts at paragraph 118. So this is back in file 1, tab 11, page 968. And if you go over the page, you can see that there is discussion starting at paragraph 120 of the court's approach in previous comparable cases. And in that paragraph, the court identifies the approach it's taken in discontinuation cases. And the court, your lordships and your ladyship can see a distinction drawn between discontinuation cases and cases of acquittal on the merits. And the first point is the point from the Minelli case, dealing with discontinuation cases, and you can see what they say at paragraph 37 of that case set out, that the presumption of innocence is violated if without the accused having previously been proved guilty or having the opportunity of exercising his rights of defence, the judicial decision reflects an opinion he is guilty. And then this may be so, even in the absence of any formal finding, it suffices that there's some reasoning suggesting that the court regards the accused as guilty. And there's then discussion of the difference between discontinuation and acquittal cases. And then at 122, second half of the paragraph, the Seconina principle appears to seek to limit the principle established in Minelli to cases where criminal proceedings have been discontinued. The case law shows that in the latter cases, that is discontinuation cases, the Minelli principle has been consistently cited as the applicable general principle. And if you look at the footnote there, you can see there is another reference to Capot. So the court is clearly understanding that in a discontinuation case, requiring a person to prove that they're innocent as a precondition of getting compensation is a breach of this principle. And then at 125, the court says there's no single approach, and that depends on the nature and context of the proceedings in which the impugned decision was adopted. Then at 126, it makes the point about the critical importance of language. And then at 127, it comes on to consider the application of the principles in this particular case. At 128, we see the point that the wording of section 133, as it then stood, could not of itself be a breach of the presumption of innocence because it's virtually identical to Article 3 of Protocol 7. And then at 129, there is the point about the strict limits under 133, and that it's for the domestic courts to interpret the legislation to give effect to the will of the legislature. In doing so, they were entitled to conclude more than an acquittal was required for a miscarriage of justice to be established, provided always that they didn't call into question the applicant's innocence. And that is, of course, premised on the fact that this was not a case where it was being said that the wording of 133 itself breached the presumption of innocence. Then the court makes the point at the top of page 972 that they don't need to distinguish between all of the nuances of what was decided in Adams. What they've got to look at is the decisions in this particular case. Then they discuss the judgments themselves, and then we come to the critical paragraph 133. It's true that in discussing whether the facts of the applicant's case fell within the meaning of miscarriage of justice, both the High Court and the Court of Appeal referred to the contrasting interpretations given to that phrase by Lords Bingham and Steyn in Mullen. As Lord Steyn had expressed the view that a miscarriage of justice would only arise where innocence had been established beyond reasonable doubt, there was necessarily some discussion of the matter of innocence and the extent to which a judgment of the CACD quashing a conviction generally demonstrates innocence. And then they refer to the explanatory report. And they say it's wholly understandable When seeking to identify the meaning of an ambiguous legislative notion, such as miscarriage of justice, that has its origin in provisions figuring in international instruments, national judges should refer to the international case law and their drafting history. However, the explanatory report itself provides that although intended to facilitate the understanding of the provisions in the protocol, it does not constitute an authoritative interpretation of the text. Its references to the need to demonstrate innocence must now be considered to have been overtaken by the court's intervening case law in Article 6.2. And we say that is an extremely important passage because the court is there saying definitively that paragraph 25 of the explanatory report is wrong and is inconsistent with the court's case law, and it's specifically inconsistent with Capo and Puig Panella. And then they go on, in this critical paragraph, what is important above all, note that, important above all, is that the judgments of the High Court and the Court of Appeal did not require the applicant to satisfy Lord Steyne's test of demonstrating their innocence. The High Court emphasised the facts of Mullen were far removed, and so on. Now, my submission, you can only read that paragraph as saying that if the High Court and the Court of Appeal in this case had required the applicant to establish innocence in order to be compensated, there would have been a breach of 6.2. Otherwise, that paragraph 133 makes no sense at all. And we get that both from the court's rejection of the explanatory report and from the importance that they attach to the fact that the domestic courts did not follow Lord Steyne. And of course, what's said effectively by the Court of Appeal in this case is, well, that may be so, but it doesn't matter because the amended 133 doesn't require you to establish innocence. All it requires you to do is to show that the newly discovered fact establishes your innocence beyond reasonable doubt. Now, I'm going to come a bit later to why that's a meaningless distinction, but it fails on its own terms because, as we've already seen, both paragraph 25 of the explanatory report and Lord Steyne were specifically addressing a situation in which it is the newly discovered fact which establishes innocence. Neither of those sources was concerned with the question of innocence in general, as the Court of Appeal would have it. So we say this paragraph is absolutely definitive, makes it clear that 133, as now drafted, could not stand. Then at 134, the Court does not consider that the language used by the domestic courts, when considered in the context of the exercise they were required to undertake, can be said to have undermined the applicant's acquittal or treated her in a manner inconsistent with her innocence. The courts directed themselves as to the need to establish there was a miscarriage of justice. In assessing whether a miscarriage of justice had arisen, the courts did not comment on whether, on the basis of the evidence as it stood at the appeal, the applicant should be or would likely be acquitted or convicted. Now, my lady, my lords, you see again there, the court specifically referencing the fact that it's looking at the new evidence and it's saying this decision is okay because the courts are not saying on the basis of the evidence as it now is has this person proved their innocence. And then they say, equally, they did not comment on whether the evidence was indicative of the applicant's guilt or innocence. Again, the evidence, the new evidence. They merely acknowledged the conclusions of the CACD, which itself was addressing the historical question whether, had the new evidence been available prior to or during the trial, there would nonetheless have been a case for the applicant to answer. They consistently repeated it would have been for a jury to assess the new evidence had a retrial been ordered. And my lady, my lords, in our submission, again, the answer to this case is clear from paragraph 134. It's all right to say it's a matter for the jury. It's not all right to say, on the basis of the new evidence, you haven't proved your innocence.
So what could 1ZA, or whatever it's now called, say?
Sorry,
what could 1ZA, or whatever
we know from the case of Adams, which I'm sorry,
all right, you're in a hurry, yes, go on.
If you're prepared to give me another 5 or 10 minutes, but we know from...
I'm afraid, Miss Rose, we can't do that.
No.
Because one of us has to be away.
No, belay the question, Miss Rose, ignore it.
But
we might be prepared to give you 5 minutes tomorrow morning.
I'm very grateful, my lady. Do I need to stop immediately? Is that I don't want to cause anybody any inconvenience, but
I think the most sensible thing is for us to rise now.
Yes, my lady.
Sorry to have to cut you short, but that is the case.
I understand, and I will seek to negotiate with justice and see if...
I think we'll have time. think we'll have time tomorrow morning. Negotiate with the others.
I will. I'm grateful.
Because we do need to hear you on the innocence generally.
Yes, it is
Innocence
obviously
from the new fact point.
I might need 10 minutes, my lady.
Well, you've got some negotiating to do.
Yes, I will
Not
try
with
to.
us.
But not with us. Apologies for this, but it is just one of those things. And we'll look forward to hearing from you tomorrow morning.